Today's hearing. We're going to begin today by hearing evidence from another former member of the Kensington and Chelsea Council. Yes, Mr. Kinnear.
So thank you. May I call Sam Mackover?
Thank you. Good morning, Mr. Mackover. I understand that you're going to make the affirmation, so if you'd read the words on the screen, please.
I do solemnly, sincerely and truly declare and affirm that the evidence I shall give shall be the truth, the whole truth and nothing but the truth.
Thank you very much. Do sit down and make yourself comfortable. Right?
Yeah.
When you're ready, Mr. Kinnear.
Thanks, sir. First of all, would you please confirm your name for the record?
Sam Mackover.
Thank you. Now, if any of my questions today are unclear or too long, please say so, and I'll rephrase them. Secondly, if at any time you would like a break, please say so. Thirdly, if during the course of your evidence, would you mind keeping your voice up? That's so that the transcriber can capture everything you say. And finally, please don't nod or shake your head in response to an answer. Simply say yes or no, so that too can be caught by the transcriber.
Yes.
Now, you have provided three statements. The first is a statement given to the Metropolitan Police dated the 30th of July 2018, and that can be found at MET 000065143. You provided a first witness statement to this inquiry dated the 28th of September 2018, and that can be found at RBK 000029923. And finally, you provided a second statement to this inquiry on the 29th of September 2019, which can be found at RBK 000054434. Have you read each of those statements recently?
Yes, I have.
And you can confirm their contents are true?
Yes.
And have you discussed your evidence with anyone before coming here today?
No.
Now, the first topic I'd like to discuss with you today is the HPSC procedure itself. And can we begin by looking at the first document you exhibit to your first witness statement for this inquiry, and that can be found at RBK 000-33748/2. And we see there at Article 6.01 of the RBKC Constitution, it sets out the general duties of the Scrutiny Committee. And if I could ask to turn over the page to page 3 and Article 6.03 at the bottom of that page. That sets out the terms of reference of the Scrutiny Steering Group, and below that, the Housing and Property Scrutiny Committee. Now, would it be right to say that in discharge of your functions that your committee would have scrutinised safety, in particular fire safety, insofar as it affected residents of properties owned by RBKC?
Yes.
And is it right that the committee had no decision-making power but could inquire, discuss and question the actions of the council, the council's officers and the TMO?
Yes.
Although the extent of your scrutiny would depend, I assume, on the sufficiency and adequacy of the information with which you're provided. Is that a fair comment?
That's right.
And notwithstanding those limitations, one thing your committee could do would be to set up a working group to examine a particular issue. Is that correct?
Yes.
And that working group could delve into a matter in more detail and question officers and other relevant individuals. Is that right?
In my experience, typically on a working group, it would be a small number of committee members who would discuss most likely a future issue in more detail, and it wouldn't really be a matter of questioning officers or anybody else, but in developing a new policy or way of dealing with something, and you'd have access to information that could be provided.
And would a report set out the working group's conclusions and recommendations?
Yes.
Now, can I turn to look at fire safety in more detail and your committee's scrutiny of that topic? In paragraph 40 of your first witness statement to the inquiry, which can be found at RBK 0002993/9, in paragraph 40, you say there that the scrutiny of borough-wide fire safety fell within the remit of the Cabinet and Corporate Services Scrutiny Committee. Is it nonetheless correct to say that your committee scrutinised fire safety if and insofar as it affected RBKC's housing stock?
Yes.
And in particular, your committee scrutinised the TMO's approach to the discharge of its fire safety obligations?
Yes.
Now, as we see there at paragraph 41 of your statement, you go on to say this, and I quote, HPSC members received information on fire safety across the TMO estate from reports and updates provided by the Director of Housing, a TMO representative, and in the Cabinet members' report. I recall that various updates were provided at HPSC meetings from 2014 onwards on installing flat entrance doors compliant with fire safety standards. Now, in scrutinising the actions of the executive in the way that you did, would you consider RBKC's own health and safety policy to give you a benchmark against which to judge the TMO?
I never saw one, and that it links into the paragraph above, because it was only much later that I recognised that there was a policy framework that was happening elsewhere from our own scrutiny committee.
When you say later, can you remember when?
Yeah, I think it was referred to when one count. I think it was probably after either the Trellick or the Adair fire, when one of the scrutiny members said, why is there a stay put policy? And whoever was answering the question, it may have been the TMO, said that's determined on a borough-wide basis.
Were you aware of RBKC's own general health and safety policy?
No.
Could I just take you to, though, a version of it dated January 2014, which can be found at RBK quadruple 01655. Has quite a distinctive front page. But is it right to say then, given what you've just said, you never saw that during your time as a councillor on the scrutiny committee?
Correct.
Could I nonetheless just take you through some of the provisions of it? And could I ask us to go to page 3 and the first paragraph under the introduction? It says there, this policy sets out the strategic fire safety vision objectives of elected members in the Executive Joint Management Team. It describes the way in which we effectively manage fire safety based upon British Standard Publication PAS 7, Fire Risk Management System Specification. Now, given its importance, was this policy never referred to by Laura Johnson in any submissions she put before you?
I never heard it or recall seeing it referred to.
At all?
At all.
Now, looking at the 4 lines emboldened under that diagram, which say plan the direction of fire safety management, do, profile the fire risks, organise and implement controls, check that fire safety management is working, act on improving safety management. Do you agree that as scrutiny committee chair, you had an important role in checking that the substance of those matters had been complied with both by RBKC and TMO?
Yes, rather than an overall policy way, in whatever information was provided to us, those are what we would be making sure that was done.
And self-evidently, if you'd had this policy framework available to you, do you think the nature, extent and ferocity of your scrutiny would have been improved?
Certainly the nature and extent. I don't think it was ever in our nature to do anything that way.
Okay. If we can turn to paragraph 2.2 at page 4. It deals here with the scope of the policy and says this, and I quote, "This policy will apply to all premises where the council has a duty as the employer and or as the responsible person, as defined in the 2005 order. This policy will also apply to any premises where, by virtue of a contract or tenancy agreement, other parties have duties of the responsible person, but where the council retains landlord responsibilities." a local fire policy for residential housing based on the housing stock risk profile would be put in place by the Housing and Regeneration Department. Now, that suggests that the policy would apply to housing stock managed by the TMO, whether as responsible person or a landlord. Would you agree with that proposition?
Yes.
There is there in the final sentence a reference to a local fire policy. Can you help us as to what that's referring?
I don't. I assume there was. I have to assume now that there was one reading it here, but we never saw it or therefore could scrutinise it.
Do you have any recollection of any reference to a local fire policy being made in submissions to you or raised by officers?
No, the term is not familiar to me.
Now, if I could ask you to turn over the page to page 5 and look at the 4th paragraph. It says there, and I quote, "The council has an appointed corporate health and safety team to provide competent advice." It then goes on to say that the corporate health and safety team will ensure that there are appropriate processes in place to ensure our partner organisations have suitable and sufficient fire safety management systems in place. Now, from that paragraph, it would appear to be clear that the council had its own health and safety team, which could provide advice and support to the TMO as a partner organisation. Would you agree with that?
Yes, from what I see here.
Can you recall in your time on the scrutiny committee whether there was any reference to advice or guidance given by the council's in-house health and safety team to the TMO?
No reference.
Could I ask you to turn over the page to page 6 and paragraph 2.5? And it's headed Responsibilities of Elected Members and says this: a cabinet member for each borough will be nominated to lead on health and safety matters. Elected members will ensure that health and safety is adequately considered when making decisions at a strategic level. This will be through an annual report on the health and safety profile of the organisation, provided for public scrutiny at the appropriate scrutiny committee for each sovereign borough. Now, again, I'd suggest to you that's plain that the policy envisaged a role for the scrutiny committee. Would you accept that?
Well, the appropriate scrutiny committee, that's where my thinking is that I must have gone to what looked like from the Constitution, the Cabinet and Corporate Services Scrutiny Committee. It certainly didn't come to my recollection, to Housing and Property.
Thank you. And if we could go now on to page 13 and paragraph 4.1, and in particular the 3rd paragraph under 4.1, it says there, and I quote, "All incidents should be reported using the online system. Incidents should be investigated by the manager. Consideration should be given to any system solutions to avoid future occurrence." And this is the bit I wish to emphasise. Corporate health and safety will investigate serious incidents when enforcing bodies such as the LFIPA are or may be involved. First of all, were you aware of, even if you hadn't seen the policy, were you aware of that provision or that rule?
No.
It would seem on its face to apply to regulatory notices served by LFIPA, wouldn't it?
I think what I'd say there is that I remember in audits or in annual updates from the TMO, there was reference to a health and safety team or something like that on many occasions, and therefore I can't say whether this is referring to an RBKC or a TMO health and safety team, but it did appear, that phrase, in the annual and 6-month update reports.
And can you remember there being much, if any, discussion on your committee when regulatory notices were served by any regulatory authority? Those linked to the DERTA?
I can only think of one instance in my time of chairing, which I think, or maybe just before, which was the Adair, where after that there was, I think, an enforcement notice. But that's the only time I can think that there was some reference made to it. I think it was in an oral update first.
Thank you. Can I now turn to attendance at HPSC meetings? And as far as we can make out, the first meeting that you attended was in July 2011. Does that sound about right to you?
It would sound right. I was just started then.
Now, I would like to ask you about some guidance that was available to councillors who were concerned with fire safety. And first of all, a guidance entitled Extinguishing the Risk, A Counsellor's Guide to Fire Safety. And that can be termed up at TMO 100037396. Now that's dated January 2010. Can you remember seeing that document before today?
No.
Next, can we turn to a guidance entitled Counsellor Guide on Fire Safety for Use During Estate Visits, which can be found at LFB 0001294. Now, this appears to be dated June 2014. Have you seen that before today?
Well, only this week when seeing
As a
it
result
pop
of
up.
questioning.
Yes, exactly.
And finally, can I ask us to turn up a document entitled Counsellor Guide on Fire Safety for Use During Council Meetings, which can be found at LFB 0001295 and is also dated, we think, the 25th of June 2014. Again, have you seen that document before today?
Only this week in hearings.
If you hadn't seen those three guidance documents, were you provided with any guidance on the nature and extent of the fire safety duties, discharge of which you were scrutinising?
Only in updates provided as papers on the committee. I don't think we saw any other attachments. It would be updates and reports produced by Housing or the TMO.
So you never received a document akin to a primer which set out the relevant principal duties are X, Y, Z, and you need to be thinking about these?
Don't remember seeing anything of those.
Now, staying with this particular document, we see that there is in the top half of that page a grey box which sets out the words fire safety in purpose-built blocks of flats and maisonettes in your borough. And it goes on to say this: local authorities play a vital role in ensuring fire safety within their borough as community leaders, enforcing authorities, partners to the emergency services, and as landlords themselves. Even if you hadn't seen this document, were you aware of the, quote, vital role local authorities played in the performance of fire safety?
Yes.
If we can turn over to the second page, and in particular the grey box at the top, which is entitled, What Can Councillors Do? And it says this, and I quote, do not make assumptions that fire safety has been actively or effectively managed in purpose-built blocks of flats and maisonettes in your borough. Councillors can make their boroughs safer by scrutinising how responsibilities for fire safety are met and ensuring that the fire safety in your borough is continuously being monitored and improved. What did you do during your time on the scrutiny committee to test any relevant assumptions that fire safety was actively or effectively managed?
I think that whenever a report or an update or a risk was mentioned in reference, then I think it was both me and other councillors on the scrutiny committee would very strongly focus on it.
And looking at the second element of that, how did you test assumptions that fire safety was being continuously monitored and improved? How did you go about discharging your functions in that respect?
Definitely looking at the audit reports, because to me that was a very strong evidence testing regime that was done independently of the TMO, from what I understand. From the updates, because I attached full credibility to what officers were saying. They were very responsive. If we asked questions, they would always provide us with answers. If those answers weren't clear, we would keep asking. So it was officer reports, audit, and the responses to our questions.
Did you at any time have cause to believe you were not being given the complete picture in relation to performance of fire safety duties by relevant officers, whether of RBKC or the TMO?
Towards the end, I found that we just didn't seem to be getting the amount of progress in solving what seemed to be a binary job, which was to test and, if not sufficient, replace both leaseholder doors and TMO doors. I did understand it was fair that doors get damaged, door closers get damaged, and therefore there will likely always be a list of things to get done. But by it not getting solved, that's what gave me concern. Maybe we didn't have all the information.
And when you say towards the end, can you give the panel an idea of the timing when you were concerned that matters were not progressing as swiftly as you felt they could have been?
Yeah, I think I remember several occasions where we were given very good assurances. I think one was saying that all doors are inspected on an annual basis. If anything isn't sufficient, then it's replaced. Another occasion, I think after the Adair fire, one of the councillors asked and was given the answer that all of our blocks are compliant with fire closer doors. And so after, and it's particularly when there's an incident, I think it was the Trellick fire, it may have been in March or May of 17, when me and one other councillor were very concerned that we still didn't have a solution to something that we kept coming back to every time. So even though the report was on the Trellick fire, we said, well, if there was a problem there, then what about everywhere else? And that's where I noticed there was a resistance. I think the minutes are quite polite compared with how...
I shall come on to that in due course, Mr. Mackover. Could we just stay with this document before we go on to your committee's deliberations on those matters? And if we could reduce the document on the screen to its normal size so we can see the entirety of it. And you'll see there in the bottom left-hand corner a series of questions. And rather than me read it out, I'll invite you to skim read those. And if you could indicate when you are done.
Okay. Okay.
When you sat on the scrutiny committee, were you conscious of the need to ask these or the substance of these questions?
They all seem good questions, and I think we touched on most of them.
Which ones?
Well, I was going at the end, the way it says clear policies stating modifications, maintenance works, etc. Those are something which I think would either come under planning or building control, and those were both completely outside the terms of reference for our committee.
Now, can we turn to look at a report prepared by Laura Johnson for the May 2015 Scrutiny Committee meeting? We can find that report at RBK 000-47681. And the first item of that report concerns non-compliant fire safety doors. So picking up the point you made earlier on, Mr. Mackover. And can we just have a look at that document? And if that can be put on one side of the screen and the other side of the screen put up para 45 of your first witness statement, which can be found at RBK 000-29923/10. And there you see it, paragraph 45 on the right-hand side, that you say you sent an email to Anne Wright in the Governance Department. I assume I'd looked at the forthcoming HPSC papers and wondered whether it would make sense for the TMO Council to pay for replacement of the leasehold fire doors rather than proceeding with enforcement action. And you quote the email, said, interesting reports, thanks. It might be interesting to have to hand the cost of a fire door versus cost of legal enforcement action. Is it fair to say, or is it a fair assumption, that you were referring there to Laura Johnson's report, which is on the left hand of the screen?
Yes.
Did you receive a response to the email you sent to Anne Wright? Can you
No.
remember now? You didn't?
I don't think so. I don't think I ever saw a number.
Now, can we take both of those documents down and turn to the minutes of the meeting, which are RBK 0003244/2. If we go to item A5 at the bottom and the second paragraph under that page, it says this, and I quote, in response to Councillor Bakhtir, Ms Johnson advised that TMO tenant doors were checked for fire safety compliance as part of an annual programme and replaced if non-compliant. She agreed to provide an update to the committee on the exact number of non-compliant TMO tenant doors. And if we go on further, you'll see Councillor Pascal thanked the TMO and officers for the follow-through and continuing work on fire door compliance. And if we turn over the page, we see they move to other related matters or housing-related matters. Does the quotation there that Ms Johnson advised that TMO tenant doors were checked for fire safety compliance as part of an annual programme, do you think now that minute fairly and accurately represents what you were told at the time?
Yes.
Now, bearing that in mind, can we now turn to the question of the Adair Tower fire, which you referred to earlier on? And just to give you some chronology to fix the questions, on the 12th of October 2015, the LFB issued a deficiency notice in relation to Adair Tower. And so you know what I'm talking about, we can turn to it at TMO 00842271. There you go, and the various identified deficiencies are at page 3. And if I could just start at page 3. And Article 11, a failure to monitor and review significant findings to ensure works have been completed. And if we turn over the page, Article 17, failure to maintain the fire resistance of the protected route. The route being compromised by fitting doors that did not have 30 minutes fire protection, and some self-closing devices were missing. And then at the bottom of that page, Article 8, general fire precautions identified as significant findings in the fire risk assessment had not been implemented. My first question is this: were you ever shown a copy of this notice, Mr Mackover?
No.
Would you agree that it highlighted significant failings which had been identified in fire risk assessments?
Yes.
Would you have expected the fact and substance of this notice to have been brought to your attention and swiftly after its service?
Yes.
Was it ever brought to your attention either by Miss Johnson or anyone else in the Housing Department?
No. This is the deficiency. Is that right? Yeah, I'd never seen this.
Now, if we can put that document down, we know that a fire broke out at Adair Tower on Saturday the 31st of October 2015, and there was a meeting of the HPSC on the 5th of November 2015. And if we can go to the minutes of that meeting, which are RBK 00047688/6, and hopefully turn to item A7, live issues reported by Director of Housing. And I quote this: Mr Black provided an update on the major fire at Adair Tower which had occurred on Saturday the 31st of October on the 3rd floor. He reported the investigation was ongoing, but the emergency planning in place had worked and the fire doors had also worked well. He explained the timelines for tenants regaining access to their flats and the rehousing of those unable to return. The chairman stressed the severity of smoke damage and how that can affect one's possessions. Mr Black said that TMO was working with tenants to ascertain what they could still use, and he said that it was compulsory for all tenants to have their own home insurance. Councillor Blakeman asked why tenants were led out of smoke-filled stairways and consequently had to be treated for smoke inhalation. Mr Black explained that the policy was to stay in your flat and wait to be rescued by the natural reaction of people was to flee. He said that there was no main alarm system, but the fire brigade had arrived within 2 to 3 minutes. Would you agree that there is no reference there or no record of Mr Black referring to the notice of deficiency of the 12th of October?
Agreed.
Do you think he ought to have brought that to your attention as a committee?
Absolutely.
Now, You also mentioned in your witness statement the mid-year review on TMO performance, indeed adverted to it earlier on in your evidence today, and that was a report prepared by Laura Johnson. And if we can go to paragraph 51 of your first statement, which is at RBK called 000 29923/12. And you'll see there you quote section 8.1 of the mid-year review that was put before your committee by Miss Johnson. Would you agree that there's no mention of the Adair Tower fire there?
Yes, there's no mention of it.
Now, in evidence yesterday, when I asked Mr. Marshall about this, he indicated that papers for your committee tended to be circulated between 7 and 10 days beforehand. Would you agree that that's an explanation as to why there's no reference to the Adair Tower fire here?
Yes, and also I'm seeing it's a mid-year review, and so it may cover a period that ends before Adair happened.
Thank you. And there's also no mention of deficiency notices there. Would that have been the subject of an oral update from Miss Johnson if it wasn't mentioned in the report that was put before your committee?
Yes.
Can you remember whether it was raised by her?
I never heard it mentioned at all.
Would it have been your expectation that it is the type of information that Miss Johnson ought to have brought to your committee's attention?
Either her or the TMO. This is one of the most important things for us to know if there's any problem like that at all.
Now, Ms Johnson prepared a report for your committee meeting on the 6th of January 2016, and that can be found at RBK 000 32439. And if we can turn to page 5 of that document, and it's paragraph 4.6 at the very bottom of the page, Mr Mackover, and I shall read 4.6 and 4.7. The TMO has been advised by the LFB that the Council TMO will be served with 2 enforcement notices as a result of the fire risk assessments the Brigade undertook following the fire at Adair Tower. 1 enforcement notice will cover Adair Tower and 1 will cover Hazelwood Tower. The 2 towers were built to the same design, having 2 separate staircases, 1 for accommodation access, the main staircase, and 1 for emergency, the escape staircase. 4.7. The TMO has yet to receive the actual notices, but has been advised that the key matters of concern relate to the design of the main staircase, ventilation system, and the lack of self-closers on the individual flat front doors. It should be noted that the TMO has agreed with the Council to fit self-closers to all flat front doors within both Adair and Hazelwood Towers, and the fitting programme has now commenced. It is expected that the notices should be received in the next week or so. Did you read that report before the meeting?
Yes.
What was your reaction to the prospect of the service of enforcement notices?
I think it was the first one that I'd ever seen mentioned in the papers, and I thought, this is very serious. How did it come about?
Did you make, as a result of that reaction, did you make any further inquiries of Miss Johnson as to how the fire risk assessments had not dealt with these matters before the fire?
I can't remember exactly how the full meeting went, but typically with a number of councillors there, if someone else asked the question that you had in mind, it wouldn't be whether I made it. But certainly it's a sort of question that that would come up.
My question wasn't really directed to what was asked at the meeting. It was in advance of the meeting. Did you make any further inquiries of Miss Johnson in relation to the effectiveness of the FRA regime applied by the TMO?
To Ms Johnson in advance?
Yeah.
No, I would only ever speak to officers at the meeting itself.
And was that may not be the right way of putting it, was that a deliberate self-denying ordinance? You'd only question them in the meetings? I don't think it was self-denying. I think it was the right forum that it could any questions about any issue could be heard by everybody and minuted. Thank you. Now, Mr. Black addressed the meeting on the 6th of January 2016, and if we can go to RBK 000 14534/11. And you see that A13 at the top of the page under the heading Live Issues, report by Director of Housing, fire at Adair Tower. I'll invite you to read that.
And this is November, is it? Or
January.
January, right,
2016.
okay.
6th of January 2016. I can take you to the front page of this. If
No, that's all right. It was just getting chronology. Thank you. Yeah, read.
Now, Mr. Black, would you agree, made it clear that the LFB's concerns weren't limited to Adair and Hazelwood Towers, but applied to the TMO estate as a whole. Would you agree with that?
Yes.
In light of that concern, what questions were put to Ms. Johnson or Mr. Black about the effectiveness of the annual programme of checks on tenant doors?
I can't remember the conversation. I don't know whether there's something in the minutes that would help.
We'll come on to
Yeah.
that, but can you remember any particular matters which were raised in discussion during the course of the meeting?
No.
No. Did the committee consider asking the TMO to submit its proposed response to the LFB for its review before it or after it was served on the LFB?
No.
Would that have been a helpful stance to take, or is it something you felt was not appropriate at that stage?
It appeared that the TMO and its advisors were on top of the issue, that the housing department was on top of the issue, and it may have felt to me thinking about it that would be quite detailed management when there are a series of professionals who full-time look at these things.
Was there any request for the TMO to set out and confirm its writing its proposed programme of responsive action to deal with the deficiencies and problems identified in the enforcement notices?
No.
Now, you assumed the chair of HPSC in 2016, I think, and your first meeting was on the 13th of July 2016. Does that sound about right?
Yes.
Now, a report was prepared by Laura Johnson for that meeting, which included a section on the enforcement notices for Adair and Hazelwood Towers. And if we can go to that, it's at RBK 000-32476. And if we can look at paragraphs 1.3 and 1.4 on that first page, they're lengthy paragraphs, so I'll simply invite you to read them to yourself, and could you indicate when you've done so?
1.3 and 1.4.
Yes, please.
Yeah. Yes.
Now, what is apparently clear from those
Well, I'm sorry, did you get a chance to read
Yeah,
it?
yeah. I'd like to just check the second page. Thank you.
Yeah.
Yeah. Okay.
Would you agree that it's clear from those two paragraphs that so far as the enforcement notices are concerned, the key points are, or key concerns are, the self-closing devices and ventilation to staircases and lift lobbies? Is that a fair summary?
Yes.
It's also clear, would you agree, that the TMO and RBKC have agreed to ensure that all flat entrance doors were sufficiently fire rated with self-closing devices at Adair and Hazelwood? Again, is that a fair summary?
Yes.
Now, can we look at the minutes from the meeting at which this report was presented? And those minutes can be found at RBK 000-32473. There we go, you're identified as the chair, 13th of July 2016. If we go to page 5 and item A9, again under the heading Live Issues Report by Director of Housing, it says this, and I quote, in the first paragraph, referring to LFB enforcement notices, Councillor Nichols asked whether the council complies at other locations. Mrs. Johnson confirmed that this was so, but said that all blocks were different, although door closers were uniformly fitted. She added that the council would ensure that the required works to Adair and Hazelwood Towers were carried out. The council would robustly defend itself against LFB action, as it had done all it could in the circumstances. Now, Laura Johnson appeared to confirm to your committee that RBKC complied with the items specified in the enforcement notice at other locations. First of all, is that your recollection of what she reported to the committee in July 2016?
Yes.
Did that fit? Was that consistent with the report, the substance of the report that Mr. Black had made to your committee?
Sometimes, well, just thinking about it, they're not talking about exactly the same thing.
And just,
Yeah.
it may be well be, if we leave this page up on the screen, could I ask another one to be put alongside? And that's RBK 000-14534/11. And if we look at A13, in particular the last three lines, Mr. Black confirmed this would be done for Adair Tower and Hazelwood Tower, but the notice related to all estates which would need to be looked at in conjunction with the council. Mr. Black's report seems to be more caveated and less emphatic than Miss Johnson's. Is that a fair comment on what you heard?
Yeah, and this is at the same date, the same meeting.
Yes. Would you agree with that?
Yes.
Laura Johnson goes on to say that the council would robustly defend itself against LFB action. Did that statement give you cause for concern at the time?
It did slightly stick out because it wasn't exactly clear to me what LFB action would be if the council and the TMO were going ahead and complying with all the requirements.
Her focus appears to be on defending LFB action as opposed to remedying the problems identified in the enforcement notices. Is that a fair summary of how she reported matters to you at the time in January 2016?
I don't remember the exact words said, but when the minutes are read at the subsequent meeting, I don't think me or anybody else disagreed with it, so I take the minutes as correct.
Could we put both of those documents down and turn to paragraph 62 of your witness statement, RBK 000-29923/16? And you refer there to a paper presented to the 16th of November 2016 HPSC meeting, which stated that all of the works required by the enforcement notices had been carried out. Now, if we can go to RBK 000-32475, we should have the minutes of that November 2016 meeting. Now, those minutes, Mr. Mackover, we can go through them if you'd like, but those minutes, there's no mention of that particular aspect of Laura Johnson's report, i.e. that all the work had been carried out, or fire safety more generally. Can we read into the absence of any reference that the committee was satisfied with what had been done and there was no further discussion of either of those points?
Yes.
Now, you also mentioned, if we can put down the minutes, you also mentioned at paragraph 62 of your witness statement that the TMO mid-year review report was prepared for that meeting, i.e. the November 2016 meeting. Was that the last report you had before the fire on the 14th of June 2017?
I think so.
Now, if we can stay in your witness statement but go to paragraph 65, which is at page 17, just over the page. You say there, just to confirm that, I believe that this was the last report from the TMO management before the Grenfell Tower fire. This report provided assurance to HPSC members that the TMO is working with the relevant authorities and specialists to manage fire safety across the estate. I was not aware of any outstanding issues or concerns at any TMO property. By that, do you mean you weren't aware of any concerns, issues, as at the 16th of November 2016?
Yes.
Did you have any concerns about the extent to which the TMO RBKC had satisfied the LFB's concerns about self-closes, for example?
I went on the assurances that they were fitted and that the works that were done at Adair and Hazelwood, and therefore I took that and the audit report and the health and safety report details as satisfying.
And particularly absent any further concerns reported to you?
Yeah.
Can I now turn to the deficiency notice that was served by the LFB in relation to Grenfell Tower on the 17th of November 2016, so the day after your meeting? And just so that you can familiarise yourself with the document, it can be found at TMO 100172554. And if we could turn to page 5. You'll see there set out a series of identified deficiencies, and just going through them briefly. Article 11, multiple items in common parts. Several fire doors did not fit fully into their frames, and there was a breach in the services duct. Article 17, several fire doors didn't fit fully into the frame. Article 17 again, the protected route had been compromised by the fitting of doors that didn't close. Flats 44 and 153 were checked and did not self-close. Article 14, emergency routes or exits were inadequate in that there were various items stored in the common parts. Article 14 again, emergency routes were inadequate in that 2 doors did not self-close. Article 8, smoke spread precautions were inadequate due to a breach in the services duct on the 8th floor. And finally, Article 15, fire action notices hadn't been displayed. My first question is, were you aware of the fact or the substance of this notice of deficiency?
No.
Again, is this the type of issue that you would have expected to have been reported to your committee, either by Ms Johnson or Mr Black?
Absolutely.
Would you agree it's now beyond doubt that the LFB were concerned at self-closures now in numerous TMO high-rise buildings?
Well, certainly this one in front of us. I don't know about any of the others.
And if we can go back to page 1 of this notice, you'll see there at the end of the first paragraph the recommendation that action should be taken by 18th of May 2017. Given that deadline, would you agree that time was, relatively speaking, of the essence?
Yes, not just time, but any of the risks like this should have been sorted out. Absolutely top priority.
Could we now turn to your meeting on the 4th of May 2017? Now, before that meeting, a fire had broken out in Trellick Tower on the 19th of April 2017, and that's the fire you were referring to earlier on in your evidence.
Yeah.
Now, Laura Johnson prepared a report on that fire for the meeting, and you refer to the conclusion of that report at paragraph 66 of your first witness statement. And it says there, paragraph 7.1, in conclusion, whilst it is always a concern to have had a fire, what is clear in the review of the incident to date is that all the work undertaken by the TMO to ensure adequate fire procedures and fire safety systems at this block worked well on the day. Additionally, partnership working with RBKC and the London Fire Brigade had a positive impact on minimising the disruption to residents, enabling them to return to their homes within 2 hours of the fire. Work to support the displaced resident is ongoing, and further liaison with the LFB is also ongoing. And if we turn over stay with your statement, but go to paragraph 67, you say this in the opening sentence: it is my recollection that HPSC expressed frustration that the fire door issue across the estate had not been completely resolved. First of all, did you yourself express your frustration with this state to Miss Johnson or Mr Black, or both?
At the committee, yes.
Which other councillors expressed frustration with the position?
Certainly, I think there was one, or there may have been more than one more. Not everyone is always reported in the minutes if they're saying roughly the same thing.
Is it fair to say that the majority of your committee were frustrated with the situation?
Yes.
Can we turn to those minutes? RBK 000 524 64/7. There we go, update on fire and Trellick Tower. The committee received a report with an overview of the fire that took place at Trellick Tower on 19th of April 2017 on the 27th floor. And if we go to the fourth paragraph there, the committee queried progress on the programme to install fire doors between flats and corridors and asked if all leaseholder doors have now been changed. In response, Ms Ray said that all 1,200 tenanted properties have had fire doors installed, but some leaseholders were refusing to engage. She went on to state that the fire brigade, presumably, were hoping for case law to make leaseholders to install fire doors. And then the committee requested a paper providing an update on the fire door installation programme on the council's housing estate and sent a strong message that as landlords we need to make every reasonable effort possible to have all leaseholder doors replaced. The minutes go on to record this. Councillor Condon Simmons praised the TMO for their efforts to install fire doors at Thomas More Estate and said that only 4 doors were outstanding. Councillor Blakeman pointed out that the report did not mention that the ward councillors were present on the day of the fire to provide reassurance to the community. She also pointed out that not every floor had fire safety instructions. Miss Johnson said she would ask to TMO to check that every floor had fire instructions. Now, you mentioned HPSC frustration that the door-related issues had not been resolved by this stage. Do these minutes accurately and fully reflect the extent of the frustration expressed by members of your committee?
Not accurate. Well, there's nothing inaccurate other than, but not full enough. I think there is the word strong in there somewhere, and I think that would begin to capture how I felt and others felt on hearing that this still wasn't solved.
Could you help?
So you're telling us really that the minute understates the strength of feeling.
Yeah, and whether we were being polite, and that's how it was recorded, but the feeling must have got across to everybody.
Can you help the panel give us the gist of what was missing from these minutes in terms of your committee's feelings about the situation?
I think the argument went, how can this still be outstanding? We keep getting assurances that we're solved, that the issues are solved, that if it's down to just 1 or 2 doors, as it was, I think, dating back 2 years, when I suggested, can't the council just pay for them to be done if there's an argument about it, because it must be less cost than enforcement action. This is a risk for everyone. It seems like a clear instruction. We keep having this issue come up. There's nothing more important.
You requested a paper. You made a strong message regarding the importance of the replacement of leaseholder doors. Was there any discussion about whether any further measures were required by your committee to ensure this issue was fully resolved? For example, setting up a working group?
I don't think there was any policy question about this. There was a very clear instruction that it should be done. A working group typically takes, on average, a year. There are maybe 3 meetings, and it bottoms out new issues. This seemed to be absolutely crystal clear. Get this stuff done.
And so it's fair to say that neither Miss Johnson nor Mr Black could have been under any misapprehension as to your concerns and your instructions.
That's right, and also by this stage, because I must have started to be concerned that we didn't drop any issues. I had started an issues tracking sheet where every request that the committee had made for officers to answer was put onto this tracking sheet and was kept on the tracking sheet until it had been answered.
And the tracking sheet, was that an informal tool you made for your own use and the use of your committee, or was it something that was held by the council?
I made officers do it, governance do it, and it was just a better way of tracking actions when they appeared in minutes, so they didn't get lost from every 2 months when another meeting took place. And
updates on progress would be provided for each meeting, based on the tracking sheet information?
Yes, the tracking sheet would be presented at each meeting, and when an issue was concluded, it would be the boxes would be greyed out, and otherwise it would stay as a live report due.
Now, the discussions at the HPSC meeting in May prompted email correspondence between Mr. Black and Miss Johnson. That can be found at RBK *02340. Now, you weren't copied in, and it's improbable you would have seen this chain before, but could I ask us to go to page 2? And the trigger email is one sent by Robert Black to Laura Johnson on the 17th of May, 2017 at 08:31 hours. Dear Laura, and I quote, just a quick one, Councillor CDS, who, just for the avoidance of doubt, who's CDS?
Could be Condon Simmons. I don't know another one with those sorts of initials.
Said yesterday that Councillor, I think Mackover, was being very negative about the TMO at some Conservative Party meeting the other night. This seemed to stem from something at scrutiny. He was worried about leaseholder doors and said we were not doing something. It was all a bit vague, but a bit of general chatter about how we are not performing in this area. Speaking to Barbara, she seemed as confused about what the issue is. What would you recommend? Do nothing, contact him and see if he wants to talk this through, or ask to meet him together to discuss it. I know he does not see you, but your advice and views welcome. Pausing there, do you recall whether you'd been very negative quotes about the TMO at a Conservative Party meeting at about that time?
It was there would never take place at a party meeting of any sort. This was at the scrutiny meeting. That was the one that I was describing.
But the focus of your concern was leaseholder doors.
It was all non-performing fire safety measures.
Thank you. And if we can now look further up the page that we're on, we have Laura Johnson's response. Robert, and she clarifies the position. This comes from Scrutiny Committee in the paper that we tabled on Trellick Fire. They completely failed to ask any questions about Trellick and instead focused on what Councillor Pascal knew about, which is the issue we had reported on regularly for the previous 2 years, which was leaseholder doors and the project that TMO had ran very successfully on getting leaseholders to change their doors. Councillor Mackover, instead of saying to Councillor P, presumably Pascal, can we please go back to the paper we've tabled on Trellick, then joined in, asking Janice and Barbara questions about leaseholder doors. They answered honestly and said, no, not all doors will comply. We have a rolling programme of compliance and regular checks. This then horrified them both, and they asked for a report to be brought back on this issue to a subsequent scrutiny committee. The questioning only stopped when I reminded him that the paper was on Trellick, and Janice had come to answer questions on that, rather than leaseholder doors. So in short, Councillor Mackover knows nothing about this issue. Councillor Pascal only knows what he can recollect from 2 years ago. Both are of the view that the council should pay to replace leaseholder doors, regardless of whether we would be reimbursed, as this would be safer for the block in case of fire. We've been through this before, and I refuse to open this up again as a subject for Councillor Pascal to dwell on. We therefore just need to get your team to do an update on leaseholder doors and perhaps door closers as part of the annual report you do to scrutiny in September on TMO performance. I wouldn't contact Councillor Pascal or Mackover on this. It's a non-issue that they are trying to turn into something because we've reported on it before. I think we should take back an update on health and safety to the September meeting. My first question is whether Ms Johnson's summary of your views and those of Councillor Pascal is an accurate summary of what was discussed at the meeting.
I don't think it's comprehensive enough. Can I make a few comments on
Please
that?
do.
Yeah. The first thing is that saying we failed to ask questions, when something that's presented to us is clear and satisfactory, it doesn't mean we ask questions on that. We might take a learning from that and apply it, as we had done in this case, to the rest of the TMO estate. So it's not wrong for us not to question something. It is, I think, it's a very good thing to say, how does then this risk apply elsewhere? Because we had not seen at various updates any more doubts that there were door closer issues or fire door issues, both tenant and leaseholder, it certainly reports Councillor Pascal and myself being very concerned that this was not solved, and it seemed to be contrary to the audit reports and the other half-year updates. And that is correct that we wanted a report back urgently to conclude all of this. And as soon as we had made that request, that's when the questioning stopped, because it doesn't matter whether the paper's on Trellick or not. We can ask whatever we want, and nothing would stop us from asking what's relevant.
She said that you were horrified, quotes, about the situation in relation to doors. Would you accept that as a fair characterisation of your action at the time?
Yeah, it was contrary to what we had been told and what we were reading.
And we can take it that...
And we were annoyed.
And we can take it that you disagreed with Miss Johnson's view that the question of doors was a non-issue.
That is surprising that she could say that, because we spent so many times on the committee talking about doors. I don't know what she would mean by that.
And having now seen this email chain, what would be your reaction to the attitude that Miss Johnson displayed to the question of leaseholder doors at the time?
I find the whole email very surprising, because I always regarded her and her department as very constructive and responsive and a definitely a high quality officer, and her reports were always seemed to be giving us the information that we were asking for. So this is a departure from that.
Can I ask you now to turn to TMO executive team minutes, where this issue is discussed, and I can ask you to go to TMO 00894337. And you see that's an executive team meeting at the TMO. Obvious reasons you would not be there, on the 17th of May 2017. And if we can go to item 2.6 on the first page, under the heading Fire at Trellick. Sorry, over the page. RB Robert Black noted that Councillor Mackover has been disparaging about the TMO over fire doors. RB has spoken to Laura about this at RB case, as RB KC are clear that they do not want us inspecting flat front doors. Councillor Mackover is saying that we should be constantly reviewing the fire doors. BM Barbara Matthews noted we have Carl carrying out FRAs and the LFB conducting audits, and they will pick up any doors not compliant. RB asked if Janice could write a briefing note on what we did on the programme, what was agreed with RBKC, completed, and what we do now. It was agreed that Janice would include this update in the annual health and safety report, which will go to board in July and to Laura after that. We've been informed that Councillor Blakeman has been disparaging about the TMO in public forums. Would you accept the characterisation that you've been, quotes, disparaging, close quotes, about the TMO on the subject of fire doors?
I don't know whether that's a correct, whether that's the correct word, but frustration and disappointment is how I was feeling it.
Now, this minute gives a little more detail as to the attitude of Laura Johnson and RBKC, i.e. that they do not want the TMO to inspect flat front doors to make sure they have closers. Were you aware that was Laura Johnson, alternatively RBKC's position on the question of inspection?
Not at all.
Is it fair to say that your view was that the TMO ought to be constantly reviewing the fire doors?
Yes, that looks right.
And at this stage, is it fair to say that you had in mind the risk presented to residents by having continuing problems over flat front entrance doors?
Yes, it was not just a theory. We had at reports from Adair and from Trellick that fire doors and door closers were vital, and obviously what had been picked up in enforcement notices on Adair and Hazelwood as well.
Now, given the documents I've taken you through, particularly the email correspondence between Miss Johnson and Mr. Black, and seeing this item of discussion, the fire at Trellick, if you'd known these matters then, would you have done anything differently in discharge of your functions on the scrutiny committee?
I think me and the whole committee would have raised it not just with the cabinet member, but the leader and the town clerk as well. It's the clearest indication that what we were asking about and being reassured about was not the case away from the committee.
Would you have expected a greater degree of candour from Miss Johnson in setting out to you her views and those of her department in relation to an inspection regime of flat front entrance doors?
Yeah, as I said, I thought that she and her department were very high quality and very helpful, and it couldn't possibly occur to me that what we were being told and this could be the same department or the same issue.
This would appear to be an example of the limitations of scrutiny, in the sense that your committee was dependent upon the sufficiency and adequacy of the information with which you were provided. Is that a fair observation?
Yes, and I would go maybe slightly further than that, which is it had been a concern of mine. Obviously, I don't have any experience at other councils of this, but that we were reliant on resource from the same officers that we were asking questions about. And I think I had been directed or was aware of something when I may have asked early on, or early on in training, do we have a resource? Do we have researchers? I'm told no. It makes sense for the officers who are doing that subject to also support you, and I accepted that because it meant that you were dealing with people who knew exactly the subject area that you were after. But this may be an example of where a separation of support could have been helpful.
Mr. Mackover, I've reached the end of my prepared questions. The chairman allows me usually 15 minutes to consider whether I've covered everything with you. Sir, may I have that 15 minutes now?
Yes, well, as Mr. Kinnear has explained, we have a break at this point to make sure that he's covered the questions that he thinks he needs to cover, and also to allow others who are not present in the room but who are following from elsewhere to suggest questions that they think perhaps should be asked. So we'll take a break now. I think quarter of an hour will do it, or just over. So we'll come back at 11:25 and see if there are any more questions for you at that point. All right?
Thank you.
And so I'm going to ask you to go with the usher, and please don't talk to anyone about your evidence or anything relating to it while you're away from the room. I don't think you'll have much chance. If you do, don't take it.
Thank you.
All right? Yes, thank you very much. Right, Mr. Kinnear, 25 past.
Thanks, sir.
Thank you. Would you ask Mr. Mackover to come back in, please? All right, Mr. Mackover, let's see if there are any more questions for you. Yes, Mr. Kinnear?
Thanks, sir. First of all, Ms. Mackover, a clarification. I think during the course of my examination of you, I said that two documents were prepared for the same meeting, which is RBK 000-14534 and RBK 000-32473. In fact, the first was dated the 6th of January 2016. The second was dated the 13th of July 2016. But I've discussed matters with Mr. Maxwell Scott, and I don't think I need to ask you any further clarificatory questions arising from that. But can I just apologise for giving you a misleading impression they were from the same meeting? Okay. That leads just to one final question. Is there anything else you'd like to tell the panel that you haven't said during the course of your evidence today?
Looking back on this, it seems that we would all have benefited on the committee from having the health and safety team on, and maybe with visits from the Borough Fire Commander on the Housing and Property Scrutiny Committee, because there seemed to be a gap between our practical question answering and the policy framework that we didn't have awareness of. On a personal note, I just want to express my sorrow and my sympathy for residents and for anybody else affected by this tragedy, and hope that everything that can happen now means that it can never happen again.
Mr. Mackover, that just leaves me to thank you for attending today to give evidence.
Yes, well, Mr. Mackover, I should thank you very much on behalf of the panel, all of us, for your coming to give evidence in this way. It's really very helpful to us to hear what you have to tell us about your own involvement and the activities of the Scrutiny Committee, and we're very grateful to you for coming along. So thank you very much indeed.
Thank you.
Yes, would you like to go to the usher then, please? Now, Mr. Kinnear, what do we do next?
The next item on your agenda today is reading in of evidence from the bereaved survivors and residents.
Right.
So to allow necessary arrangements to take place, because I will not be reading that in, I ask you to rise, albeit briefly, so that the cleaning and all the rest of it can be completed, and then that can start.
Well, I'm just wondering whether we do need it. It won't take very long to do that.
It won't, but I think in the past we traditionally have, but I'm entirely in your hands as to whether you want to sit here whilst it's done or rise and wait for it to be done.
Well, all right. We'll give you all a break from our presence. How's that? And we'll rise for as short a time as it takes to do the usual
I'm grateful.
cleaning.
Thanks, sir.
Right. Yes, Ms. Sivakumaran, I understand you're going to read some material.
That's correct,
For the benefit
sir.
of the panel and the public.
Indeed.
Good, thank you very much.
Now, we would now like to read into the record extracts from a number of BSR statements which concern fire safety advice. We do this against the background of the evidence on this issue that the inquiry has already received in both Phase 1 and from the BSR witnesses that were recently called in this module. I propose to begin with a statement of Mohammed Rasool, inquiry reference IWS 401768. Now, Mr. Rasool lived in flat 25 with his wife Munira Mahmood, their children, and his elderly father Abdul Al-Rasool. Mrs. Mahmood gave oral evidence during the Phase 1 hearings. She told you, Mr. Chairman, that her father-in-law suffers from dementia. I propose to pick up Mr. Rasool's statement at page 2, paragraph 4, where he explains that his parents became tenants in Grenfell Tower in 1980, with the family moving into flat 25 in 1994. And then if we go to the next page, page 3 at paragraph 13, I will begin reading from that paragraph. No one from the TMO or RBKC ever spoke to us about fire safety. I am not aware of any fire drills having taken place in the tower. At some point in or around 2004, we were given a copy of the TMO Tenant's Handbook, and he has exhibited it MR6. The handbook included a page on fire safety and security, see page 25 of Exhibit MR6, but no one had brought this to our attention. Although the handbook had some very brief information about preventing fires, it had no information about what we should do if a fire broke out in our flat or in the tower. It does not mention the fire strategy for the building. I'm not sure if every resident was given a copy of the handbook. He continues on the next page. We also received copies of the TMO's Link magazine, but I assumed this was more like a notice board and would not contain any important information. No one ever warned us that it might, so I never read it. I would have also assumed that any important information, such as fire safety, would have been brought to our attention in a more direct way, such as a letter addressed to us. The only information I saw about the fire strategy for the building was on a fire safety notice, which is by the lifts on the ground floor. I think the notice was put up after the refurbishment. It was about A5 size and easy to miss. It was only on the ground floor. As I stated in my Phase 1 statement, the notice was in English, and I am not aware of it having been made available in any other format for those with special needs. The notice said that in case of a fire, unless the fire was in your own flat, you should remain in your flat until you are evacuated out of the building. The notice did not give any information about the assembly point if the tower was evacuated. I believe that it also said not to use the lifts if there was a fire in the building and to use the stairs instead. I will stop reading there. The next statement is that of Mr. Nicholas Burton, and this is inquiry reference IWS 401661. This is the Phase 2 statement of Mr. Burton. He gave oral evidence during Phase 1 hearings. Mr. Burton lived in flat 165 of Grenfell Tower with his wife, Maria del Pilar Burton, known as Pilly. Mr. Burton lived in the tower from 1984, but his wife was a tenant from about 1975, and they became leaseholders in 1994. Pilly Burton survived the fire but died on 29 January 2018. I propose to begin from page 3 and pick up a statement at paragraph 10. We did receive written information about the stay put policy. I think this would have been in certain TMO newsletters, but I cannot remember when we received these. I was aware of the concept of compartmentation, so I could see why it would make sense to stay where we were in the event of a fire, because it should be contained. When I worked in hospitals, we were told that the different wards were different compartments, so in the event of a fire, we were supposed to evacuate if the ward we were in was the one affected. But we were otherwise, in theory, safe to stay where we were. We nevertheless undertook ward evacuations with patients so that we were fully prepared. Even during the fire, I remember thinking that staying where we were was the best thing to do, and this was backed up by the advice that I was being given by the LFB during the emergency calls that I made. I really did not know how bad it was until I looked over to the north side of the tower and saw lots of blue lights. All the traffic stopping on the motorway and the reflection of the blaze on the glass front to the school. I do remember seeing the new fire safety signs at the lifts. I remember I went down to the other floors to check that the new signs have been put up there too. We discussed this at a GTLA meeting, but if I remember rightly, it was more about the delay in them putting up the signs than the nature of the advice. And this is where I propose to stop with Mr. Burton's statement. The next statement I turn to is that of Mustafa Abdu, and the reference is IWS 401956. Mr. Abdu lived at flat 184 of Grenfell Tower, and this was on the 21st floor. I propose to pick up his statement on page 6 at paragraph 26. There's the heading Fire Safety Signage. And Mr. Abdu said, I do not remember there being any fire safety signage before the refurbishment. The first fire safety signage I remember were signs advising on the stay put policy. These were in the lift and lobby corridors at the tower. I remember from this that in the case of fire, you should not use the lift and should go back to your room and shut the doors and windows. And then if we move forward to page 6, paragraph 41, I will then pick up his statement again, where there's a subheading, Fire Safety Advice, and he said, I have lived at the tower for 27 years and I never remember receiving any advice about fire safety. I did not feel at the time that we were properly briefed or trained about fire safety either. On the next page he continues, I do not recall any fire safety officer talking to me about fire safety in the tower. My solicitors have asked me whether I remember anything about the resident magazine Link. I cannot remember ever hearing about Link, and despite talking to others, I cannot ever remember them mentioning the Link magazine either. It seemed to me that no one was aware of it. I do not remember ever receiving any newsletters during the refurbishment period about fire safety advice. I will usually look at my mail and read it if it comes through the door, so I cannot imagine that I would have missed it. The only advice I remember is the plastic stay-put signs set up in the lift and lobby area. In the event of a fire, I thought I had to go to my flat and remain in there with my doors and windows shut because that is what the signs in the lobby and lift areas said. And that's where I propose to stop. I will then pick up with the statement of Rebecca Ross, and the statement references IWS 401826. Miss Ross lived in flat 122 on the 15th floor of Grenfell Tower with her father, Stephen Power, and her brother, Bobby Ross, and their 3 dogs. Miss Ross was 22 years old at the time of the fire. Her father had moved into Grenfell Tower in 1985, and he died on the night of the fire. I propose to pick up her statement at page 8, paragraph 35. There's the heading at the bottom of the page, Fire Safety in Grenfell Tower. And Miss Ross says, as stated above, my understanding was that the TMO had overall responsibility for fire safety within the tower, but I knew that RBKC owned the tower and was the landlord. She continues at the next page, I was not aware at the time that there was a stay-put policy in place at Grenfell Tower. There may have been signs in the lift lobbies about this, but this was not something that I took notice of, so I didn't know we had this policy or what it meant. I have never taken part in a fire drill at Grenfell Tower, so I didn't have any experience of what to do in case of a fire. In the time that I lived there, there were only a few small fires, which never spread out of the flat in which they started. If I had needed to evacuate the tower, I wouldn't have known to go to a designated place outside. I remember receiving a magazine called Link through my front door. However, I wouldn't have known that there was any information in there about fire safety. It mainly contained information about events going on in the community. I wouldn't have known to look in there for fire safety information. I propose to stop reading there. I would note that Bobby Ross has also provided a Phase 2 statement, the reference for which is IWS 402356.
Thank you.
The next statement we will go to is that of Maria Jafari, and that reference is IWS 401815. Ms. Jafari lived in flat 86 on the 11th floor with her father, Ali Yawar Jafari, her mother, Fatima, and her sister, Nadia. Nadia Jafari gave evidence during Phase 1, and her father, Ali Yawar Jafari, died during the fire. Flat 86 was leased by the Notting Hill Trust. Although the Jafari family were designated as temporary residents, they had lived in Grenfell Tower since March 2003. I propose to pick up her statement at page 6, paragraph 22, where Ms. Jafari has addressed fire safety under the heading at the top of the page. She says, "Nobody ever spoke to us about what to do in the event of a fire. We never took part in a fire drill, and we were never given any information about where the assembly point would be if the building was evacuated. We were not warned about the lifts or told what to do or how to get out if a fire broke out. If there was a fire in our flat or next door, I would have simply left the building. From undertaking fire drills at college, I knew that in the event of a fire, I was supposed to leave the building. I never heard of stay put. I remember that there was a fire before the refurbishment, but did not hear a fire alarm. I never heard a fire alarm go off in the communal parts of the tower in the 14 years that I lived in the tower. I think there was a fire sign next to the lifts, but I do not recall reading it or understanding it. Nothing was translated or explained in person." And that's where I propose to stop with this statement. The next statement is that of Zoe Dainton, and this is reference IWS 401974. Zoe Dainton has made a Phase 2 statement, and she lived in flat 12 of the 4th floor of Grenfell Tower with her mother Jenny Dainton and her sister Leah Weeks. Miss Dainton's then partner David Benjamin sometimes stayed at the flat as well. I propose to pick up her statement at page 3, paragraph 15. And we can see Mr. Dainton said, "As already stated in paragraph 30 and 50 of my Phase 1 statement, I recall fire safety signs telling you to stay put inside your flat in the event of a fire, unless the fire was inside your flat, in which case you should leave. The sign also said not to use the lifts, but I was never told this verbally by anyone in an official capacity. I saw this sign on the ground floor and 4th floor while waiting for the lifts. I think these signs were on every floor and were there before the refurbishment. I did not really understand how stay put was supposed to work in practice, but I did not speak to anyone about this at RBKC or the TMO. I will stop reading there, but I note that David Benjamin has given a Phase 2 statement, which is with reference IWS 401764. The next statement that I will turn to is that of Lorraine Beadle, and the reference is IWS 401872. Lorraine Beadle lived in flat 13 of Grenfell Tower since 1976. I propose to pick up her statement at page 2, paragraph 8. Miss Beadle says that the emergency exit was via the stairs, which could be accessed through the lobby of each floor of the tower. But when the refurbishment started, this would often be blocked off. I remember in October 2014, I raised my concerns about this with Ryden. I called Christina Stefanou and Maxine Igbenedion, both Ryden resident liaison officers, on their direct lines. Neither answered my call. I then called somebody at the TMO, but I can't remember who. I've since learned that in response to my questions, Siobhan Rumble, neighbourhood manager for Lancaster West at the TMO, said, "In the event of a fire, as we know there's a stay-put policy, an evacuation would be via the lift, not the stairwell, and how the barrier would be moved in this case." I did ask if Ryden had notified residents, but they hadn't. This is a fault on their part, as if a letter went out, then we wouldn't be having this conversation. I've expressed the importance of making sure residents and staff know what is happening. Ms. Beadle continues, "I do not remember being given any fire safety advice from the TMO, RBKC, Ryden, or any other party, either before or after I had raised these concerns. As far as I remember, nobody from Ryden or the TMO called me back in response to my concerns about the escape route being blocked. I think that this was awful. They did not treat fire safety seriously as an issue, and this example shows this. They did not deal with my concerns well at all on any level. They just did not seem to care." That is all that I will read from this statement. Mm-hmm. The next statement I turn to is that of Bella Pastor, and the reference for the statement is IWS 401682. Bella Pastor lived in Barrington Walk with his partner Miriam Newby. At the time the statement was prepared, Mr. Pastor was 82 years old and his partner was 77 years old. I will pick up the statement from page 2, paragraph 10, where he says, Miriam and I lived in Barrington Walk for 40 years, and in that time we were never visited by the fire brigade, nor did we receive any advice from anyone about what to do in case of a fire. We were not consulted about any special evacuation plan to be put in place for Miriam or I as elderly people. And that's all that I propose to read from this statement.
Okay.
The next statement that I will read from is that of Helene Hartley, and the reference is IWS 401257. Miss Hartley lived in Hurstway Walk, and she moved into a home in 2000. If we pick up the statement at page 8 on paragraph 28, Miss Hartley has this to say about fire safety in Hurstway Walk. She says, as a joint leaseholder with NHHT, and I pause reading there just to explain that NHHT stands for Notting Hill Housing Trust.
Right.
She says, NHHT issued me with a handbook when I moved into Hurstway Walk. There is advice in this handbook to evacuate in case of a fire. However, this handbook is not specific to Hurstway Walk properties. I do not remember ever receiving a handbook from the TMO that gave accurate fire safety advice specific to my block. Prior to June 2017, I was not aware that there was a stay-put policy in Hurstway Walk. I had never been told by the TMO. There were no signs in the communal areas of Hurstway Walk stating that there is a stay-put policy. The only signs tell residents not to store belongings in the communal corridor as it is a fire risk. This is not enforced by the TMO at all, and other residents frequently keep bikes or pushchairs outside their flat. Currently, the estate management themselves and their appointed contractors store trolleys out there too. I have exhibited a photo of this, which was taken in late January 2019. I propose to stop reading there. Those are the statements that we have read which address fire safety advice. I now propose to read from the final set of BSR statements, which concern the system for reporting repairs and complaints, before turning to some evidence from residents on their perspective of the refurbishment process. Finally, there will be evidence read regarding the maintenance of flat front doors and self-closing devices. The next statement I will read from is that of Jenny Dainton, and the reference is IWS 401804. Miss Dainton lived in flat 12 on floor 5 of Grenfell Tower. I have just read from the statement of her daughter Zoe Dainton, and her other daughter Jenny Dainton had lived with her as well. If we turn to page 5, paragraph 28, I will pick up from where Miss Dainton addresses reporting issues and concerns to RBKC and the TMO. Ms. Dainton said, when the TMO started managing the tower in the 1990s, there was a noticeable change of branding. The TMO were initially more visible than RBKC had been previously. TMO staff were based in an office behind the concierge at the base of the tower. Security was also based there. You would often see staff from the TMO around Lancaster West Estate. However, this changed during the last refurbishment when the concierge disappeared and the TMO moved their office to Kensal Road. I would usually report any issues or concerns about the flat or communal areas to concierge as I was passing. I remember a gentleman called Karim, but there were others whose names I cannot remember. When I reported an issue with the lifts, Karim would normally be aware of this. I preferred speaking to Karim rather than calling the TMO's telephone repair line, who would usually write down my issue or concern on a scrap of paper with my flat number. I assumed he would then report this to the TMO on my behalf. I do not know if this information was formally logged by the TMO on any computer system. I never saw any repair book that Karim or others would record this information in. Sometimes I would have to chase this up several occasions before the work was completed. And then if we go on to paragraph 32, she continues, once the concierge and the TMO office was removed from the tower in 2014, I would call the TMO's telephone repair line. It was a 0800 number. I did not find this was very reliable. Sometimes they would not pick up. When you did report a repair or concern, you were told that someone would get back to you to arrange an appointment, but they rarely did so. You would have to chase them again. Alternatively, they would turn up unannounced, or you'd return home from work to find a card had been left saying they had attended, but no one was in. Yet I had not been given any advance notice to enable me to make appropriate arrangements for one of us to be at home to let them into the flat. It was most frustrating. I would also speak to Jan Jones about repairs to my flat, either in person or on telephone. I had her direct dial, which was separate from the TMO's telephone repair line. She was originally based at the bottom of the tower and later in the TMO's office on Kensal Road. She had worked for the TMO for a long time. Jan Jones' standard response was, "We will get back to you," but most of the time you would be ignored. It was only once the local council was involved that action was taken. I describe an incident involving a National Grid contractor drilling into an asbestos panel and how the TMO dealt with this in more detail below. On one occasion, I remember bumping into Jan Jones on the estate and asked her why the lifts were always breaking down. She told me it was an old building and that the lifts were in constant use. I felt the implication that was that this should be expected and I should not be complaining about it. When someone finally attended the flat to carry out repairs or maintenance work, they would often try to minimise the issue or blame it on you as the tenant. By the time it came to refurbishment, I was so exasperated that Zoe dealt mostly with the TMO in Ryden. If I did report any issues, I would go straight to the TMO rather than speaking to Ryden. And that's where I propose to stop with her statement. Yep. The next statement that I will read from is that of Lucy Ho, and the reference is IWS 401551. To provide some background, Lucy Ho's mother, Hong Kan Kwang, gave evidence in Phase 1. The family had moved into Grenfell Tower when Miss Ho was 3 months old, and they lived in flat 76 on floor 10. I propose to pick up her statement from page 3, paragraph 10. Miss Ho said, "Being social housing tenants meant that we could redecorate our flat, but we couldn't make improvements to it without asking the council first. And so if things needed repairing, we were reliant on the TMO organising the repairs to be made. When things in the flat stopped working and we needed something repaired, we would have to contact the TMO. Jenny and I would contact the TMO on our mum's behalf because her first language is Cantonese and she only speaks a limited amount of English, which I believe the TMO knew, or they should have known. There was a TMO helpline that we could call and we had a leaflet with their number on. You could also submit a complaint online. I do not remember making a complaint to the TMO online, but I know that Jenny had done so before. I remember that Jenny submitted repair and maintenance forms that were sent to the TMO, and I would expect that to be on the housing records. However, I've been through the housing file which my legal representative has obtained on my behalf, and I cannot see any of these records on the file. We had to be persistent with the TMO to get them to send a workman to the flat to make the repairs when we needed them to. It would often take 2 to 3 weeks before someone was sent to our flat by the TMO to take a look at what needed repairing. Quite often the workmen would say they couldn't fix the problem because they didn't have the parts to do so, which was really frustrating on occasions because we felt we had given the TMO all the information the workmen would need to fix the problem, and this would cause further delays. I conclude reading from her statement there. I note that Miss Ho's mother and her sister Jenny Kwang have provided Phase 2 statements, and their respective references are IWS 401552 and IWS 401821. The next statement that I turn to is that of Elizabeth Sobieszak. The reference is IWS 401539. Ms. Sobieszak gave evidence in Phase 1, and you'll note that she lived in flat 43 on floor 7 of Grenfell Tower with her husband and her daughter, and they'd lived in Grenfell Tower for 32 years. Ms. Sobieszak sets out her experience of making complaints to the TMO in her statement at page 2, and I propose to pick up her statement, paragraph 7 on page 2. She said, "I had very little faith in the TMO being able to sort out problems that we brought to their attention. They made us feel a nuisance, and we often had to take matters into our own hands or call on friends for assistance. When there was a fault in the flat, I would report it to the TMO's housing office, reception. The first person you would speak to would be the receptionist, who would say that they would allocate the job to someone before updating you on when that had been done and when your visit would take place. You would very rarely get a call back and would have to call again and again to report the problem, which never seemed to be handed over properly. And so you would have to waste more time repeating the same issues with very little faith that it would be actioned, that anything would be actioned. We tried to resolve things as much as we could on our own before calling for help. The other frustrating thing was that often, after waiting some time for someone to attend, thinking they would resolve the issue, they would attend just for the purposes of doing an assessment and then say they would come back, so the whole ordeal and delay would start again. It came to the point where we lost faith to such an extent that we began to just try and resolve issues ourselves or rely on friends who were plumbers or handymen. I remember thinking that they had a lot of cheek because after someone from the TMO would attend our flat, even if they hadn't resolved the issue or needed to return, they would send us a performance feedback slips through the front door for us to complete and return in the post. It wasn't just a general disregard or lack of care for the service they were providing and service users in general. And that's where I propose to stop with her statement. I note that Ms. Sobieszak's husband, Michael, and her daughter, Florentina, have both given phase 2 statements as well, and the respective references are IWS 401562 and IWS 401555. I now turn to the statement of Gitiara Palavani, and the reference is IWS 401244. Ms. Palavani lived in flat 22 of Grenfell Tower with her 2 sons and her daughter-in-law. She had lived in the tower since 1997. In her statement, Ms. Palavani recalls that she received a tenancy handbook when she first moved into the flat, and if we turn to page 3, paragraph 7, I will read what she says about it. Ms. Palavani says, "I remember that at first I was happy with the TMO. There were no real issues that needed sorting out in the flat. I was given a tenancy handbook when I moved in, and I was happy that it said if something needed repairing, then the TMO would send someone to do it. In the beginning, they did exactly that. Little things that needed fixing were done quickly and without any issue. However, things changed a few years after moving in. I addressed some of the issues with my flat at paragraph 14 to 27 below." And then if we look at paragraph 10, if we move forward, she also addresses the complaints procedure, where she says, "Whenever something did go wrong, be it an issue with the flat or something else, and I was upset with the TMO, I did not really know what to do. I was not aware of any kind of formal complaints procedure, and do not remember anyone telling us about this sort of thing. I sometimes tried to speak to Claire Williams, the manager of the TMO, the tower at the TMO. I was always just told that she did not deal with tenants and was not available. In many ways, I felt helpless, and like no one would listen to me when I had an issue." And that's where I propose to stop with her statement. As mentioned, I will now read from some statements which make reference to the refurbishment process itself and concerns raised then. The first statement addressing those issues that I will read from is that of Chantalal Patel, and the reference is IWS 401828. Mr. Patel lived in flat 56 on floor 8 of Grenfell Tower with his wife, Kiran Patel. They had moved into the tower in 1984, and both their sons grew up in the tower. They were leaseholders of their flat since 2001. Now, if I can pick up his statement at page 2, paragraph 9. Mr. Patel says, "At one point during the refurbishment, when the cladding was being fitted to the outside of the building, there were some high winds one evening. The newly fixed cladding rails rattled all night long." And then if we continue at the next page, he says, "I looked out of my window and could see that some of the bolts used on the cladding rails looked too short and suspected that some of the fastenings had not been tightened properly. This was worrying, and so I emailed the TMO to warn them of the problem. I never really got a response to my comments apart from that the rattling was only due to high winds and that this would not happen once all the cladding was fitted. A copy of some of my emails and the brief responses I received have been provided to the inquiry, and those are with URN reference RYD 30280012 and RYD 30277752. If we then look to the next paragraph at paragraph 11, he's also addressed the windows installation. He says, "New windows were fitted in my flat in August 2015. There were, however, problems with the windows that were fitted. One window had a safety catch missing, meaning the window could be opened all the way. Another was jammed shut, so you could not open it at all. To me, it was more evidence of shoddy work or poor products being used. I tried to call Linda Prentice, the liaison officer who worked for Ryden, but she did not answer any of my calls. So I emailed Claire Williams at the TMO as she was managing the refurbishment. Someone from Ryden came to my flat the following day to check the windows. I was told that someone from the window fitting team would come to fix the issue the following week. Copies of these emails have been provided to the inquiry at URN reference RYD 30049391. No one came to my flat in the weeks following to fix the windows. I emailed Linda Prentice to inform her that the windows were still broken. Linda responded to say that someone would come to the flat the following day at 11 a.m. A man came to the flat the following day, looked at the windows, and then said that he did not have the right parts to fix the window with him, and he would fix it later once more parts had been ordered. And then he continued. Apologies, I've just missed my spot. He told me that there were a number of windows in the tower with the same problem. He did manage to remove a part from the jammed window so that it could open. A copy of my emails to Linda have been provided to the inquiry at RYD 30053102. And that's where I propose to stop with his statement. I note that Chirag Patel, Mr. Patel's son, has also provided a Phase 2 statement, and that is under reference IWS 401610. I now propose to turn the statement of William Thompson, and that's IWS 402110. Mr. Thompson lived in flat 52 on floor 8 with his family, and they'd moved into Grenfell Tower in June 1997. I will pick up his statement from page 4, paragraph 14. Mr. Thompson said, in relation to any other consultation on the refurbishment, I remember seeing the new windows being unloaded from a lorry on pallets and stored in the garages under the walkways. Prior to that point, I don't recall being asked what type of windows I wanted or being offered any choice. Obviously, once they had been ordered and delivered, I do not recall being asked my view either. They had already been delivered by that point. There was a meeting in the show flat 145, when we were shown the new windows we were getting. I'm pretty sure there were 3 meetings I attended in the show flat. And it was the first meeting when I was shown the windows. This meeting happened around January 2015. I refer to it later in the statement because of comments made by Jason North of Ryden at the meeting. I vaguely remember seeing a picture of the windows, maybe on a newsletter, but I don't ever remember being told by the TMO in person the type of windows they were planning to put on the building and being asked for my view. I was never asked what I thought of the TMO plans. Conversations about the works were always in summary along the lines of, this is what you're getting, instead of these are the options. What do you think? And then if I move forward to paragraph 16, Mr. Thompson has also said, I was never asked what type of cladding I wanted on the building, but if I had been asked, it would not have alarmed me. I would not have known there was anything wrong with it. I would have expected it to be safe. The thought that it might be dangerous would not have even entered my mind. I would have thought it was just for aesthetics. It is very painful for me to think of all the things I complained about. I did not focus on the cladding. On reflection, given the TMO's history, I should have scrutinised every single thing they were doing. I then propose to move forward to paragraph 22, and this is on page 4. I apologise, page 6, possibly if you scroll forward. Mr. Thompson's continued, the refurbishment works begin, and this is the subheading, and he continues after that. After the colour of the hoardings changed, the work on the towers started, and residents began to come together to complain about the works. I remember the first meeting of residents in relation to the refurbishment works was absolutely jammed. It was in the EMB rooms, and there were residents waiting outside who could not get in. There were a series of resident meetings throughout 2015 and 16. In addition to the residents who attended these meetings, there were other residents who didn't attend, who were either too busy or didn't feel able to speak out or got tired of complaining, even though they would have wanted to, but who still supported the aims of residents who did attend. After a residents' meeting had taken place, I was often approached by neighbours who did not attend and asked how it went and offered support. My impression living in the tower was that there were some residents who became so used to being bullied by the TMO and RBKC that they just didn't want to rock the boat as they were afraid of the consequences. I'm not saying people were physically threatened, but people were afraid, especially the old and vulnerable, of which there were quite a few. That is how it is in social housing, especially when there's lots of homelessness out there. Many people do not want to speak up against a landlord because of however bad things might be, they feel at least they have a home. I used to picture some of these older and vulnerable residents sitting in their homes with no water, but scared to complain, scared of the people who are supposed to be looking after them. My former neighbour, David Collins, attended early resident meetings. He was articulate, and I felt he could be a real asset in helping residents. It was good he was there, and I'm sure he has lots of information about the refurbishment work, so it's important he can give evidence to the inquiry and comment on documents produced by those involved in the refurbishment project. He took the lead in raising complaints during the refurbishment as chair of the Grenfell Compact, when that was formed later down the line, as I described later in this statement. Eddie Defan was also a lead advocate on behalf of residents and Compact members. He knew a lot of people in the town and was a popular member of our community. He still is. I knew he co-wrote the Grenfell Action Group blog, and I often read the blog at the time and even contributed to a couple of articles which I mentioned below. Eddie was passionate about our living conditions and protecting community resources across the borough. He would get things across well in meetings with the TMO, RBKC, MPs, Ryden and others. Eddie could recall promises that the TMO and RBKC had made, things people had said, and he could remind them of this. If I could not go into a meeting and wanted someone to advocate for me, that's the person I would want to do it. He could get points across much better than most of us. He was used to meetings and knew how to conduct himself, so it's not surprising that people in the tower would go to him and to other Compact members with their problems and complaints. I could see that the TMO and Ryden realised they couldn't mess about with him. Throughout the period of time that is covered by the statement, a number of residents would therefore speak to Eddie about their problems, as they probably felt he could raise them effectively and properly hold the TMO and RBKC to account. And then if we move forward to paragraph 26 on the next page. The main driver to residents coming together during the refurbishment works was the way we were all being treated in relation to the location of the heating interface units, HIUs. But over time, residents also shared their experiences of the following, amongst other things: poor workmanship, especially around pipework and the windows; Ryden workers being rude and invading people's privacy; Ryden's working hours, that they were doing noisy work at times they had agreed not to; running water not working; changing floor numbers. I would raise issues on behalf of other residents, and they would ask me to do so. This happened even before the Grenfell Compact was formed. For example, in relation to the noisy working hours, Ryden promised not to do any noisy work children were getting ready for school, or when they had returned after school and needed to do their homework. I took it upon myself to call Ryden almost every time their workers breached that agreement, which happened frequently. I wanted to speak to someone senior, but I was always put through to the resident liaison officers. I remember speaking to Linda Prentice about this on numerous occasions. If I did not complain, then the workers would not stop their noisy work. And that's where I propose to stop reading from Mr. Thompson's statement. I will now turn to the statement of Hanan Wahabi, and the reference is IWS 401714. Now, Ms. Wahabi lived in flat 66 on floor 9 of Grenfell Tower with her husband and children. She also gave evidence in phase 1, and she told the inquiry that she moved into Grenfell Tower in October 2001. Her brother Abdulaziz Al-Wahabi lived in flat 182 on floor 21 with his wife Fawzia and their 3 children. Mr. Al-Wahabi and his family died in the fire. Mrs. Hanan Wahabi was a member of Grenfell Compact, and she confirms that she made complaints both as an individual and through the Compact in her statement at paragraph 18. However, I propose to move forward to page 6 and pick up her statement at paragraph 31. Ms. Wahabi says, the majority of complaints I had regarding fire safety were made through the Compact meetings. During these meetings, we raised fire safety complaints of residents throughout the whole of the tower. We spoke about the building of Kensington Aldridge Academy and the effect it would have on the space for emergency vehicles. We also spoke about the porter cabins which were located around the site during the refurbishment and how this would make it difficult for emergency vehicles to enter. We also raised our concerns about floor numbering to Peter Madison. Before the refurbishment, flat 66 was on floor 6. After the refurbishment, this became floor 9. We fought for the floor numbers to remain the same, given the familiarisation and the floor plans of the London Fire Brigade. And then if we move forward to paragraph 32, she continues, I detailed my involvement with the Grenfell Compact group at paragraphs 25 to 29 of my IWS, that's her inquiry witness statement, and 16 to 23 of my SIWS, and that is her supplementary inquiry witness statement, and pages 3 to 5 of my MPS Metropolitan Police statement. A group of residents, David Collins, Edward Defan, Marcio Gomez, Turafat Yilma, Antonio Roncolato, William Thompson, and myself began meeting to discuss our concerns regarding issues with the tower in around January 2015. We signed the compact agreement in October 2015. The compact group met weekly to begin with, then once a fortnight. At the compact meetings, we would voice our concerns to Peter Madison from the TMO, Councillor Judith Blakeman, and Councillor Fielding. David Collins, who was a resident of flat 185, was chairman. David Collins and Edward Defan would also send our concerns by email to the above named. I was occasionally CC'd into these emails, but the majority of the time, David Collins forwarded me any responses. And I propose to stop there with reading her statement. Oh, sorry, there is one more matter. If I move forward, if I move back to paragraph 9 on page 2, I would also note what Ms. Wahabi has to say about her flat door. She says at paragraph 9, I have previously detailed that the door broke and contact has attended to fix the door. The door had 3 hinges, but the middle hinge looked different to the other 2 as it had a chain and pole attaching it. I believe it should read of attaching it to the door. I have since viewed my housing file and been provided with the repair log for my flat. I note the log states that on 6 December 2011, OOH 1697441, remove and ease external door including any, and she's given her exhibit reference HW1. I think this may be when they removed the pole and the hinge, which was similar to the photo exhibited. I remember it was before the refurbishment started and before the previous fire. This means I was incorrect when I stated in my previous statement the door was replaced in 2014, as it appears they were replaced in 2011. And if we continue to the next page, Ms. Wahabi says at paragraph 10, the contractors removed the pole which was contained in the middle hinge of the door. The pole led from the door to the door frame. I have explained that after they removed the pole, the door was much lighter and no longer closed automatically. Despite the person who fixed the door informing me that he would be back to fix the mechanism, no one ever attended. As I explained during my oral evidence, the same thing happened with my brother's door. They took out the same hinge containing the pole and it no longer closed automatically. I called KCTMO a couple of times to request that the pole was replaced. During these phone calls, I was informed they would arrange for someone to contact me to confirm when they would attend. However, no one contacted me. When I tried to follow up by phoning KCTMO again, they would again say they would confirm when someone would be able to take a look. However, they would never call back. After a couple of times of trying, I gave up as nobody was responding. Therefore, the pole was never replaced. For this reason, I did not feel that my complaints were effectively dealt with. And that's where I propose to stop reading from Ms. Hanan Wahabi's statement. I would note her son, Zachariah Chebiuni, has provided the inquiry with a Phase 2 statement as well, and that reference is IWS 401979. Now, Ms. Wahabi's evidence about her front door takes us to evidence from other residents about the self-closing mechanism on their front doors. And I now propose to go to the statement of Turafat Yilma Gurma, and the reference is IWS 401732. Now, Ms. Turafat Yilma Gurma moved into the tower in 1996 and lived in flat 44 on floor 7 with her husband and her child. If we pick up her statement on page 3 at paragraph 6, she has this to say: I do not recalled that our flat door had a self-closing mechanism. In fact, after our door was changed in about 2014, I would estimate, I recall that we had a problem closing the door. We told the TMO about the problem, and they advised us to remove something from the door hinge to fix the problem, which we did. We also had problems with the communal doors. They would not shut properly. We complained about this issue to TMO as well. And that's all that I propose to read. I note that her husband, Abraham Abebe, has also provided the inquiry with a Phase 2 statement, and the reference for that is IWS 401796. I will now turn to the statement of Senna Matchett, which is under inquiry reference IWS 401563. Mr. Matchett gave evidence in Phase 1, and he lived in flat 133 with his wife, Hanife. I propose to pick up his statement on page 3, paragraph 13, where he has said as follows. I described in my Phase 1 statement at paragraphs 39 to 43 how my front door was replaced with a new door that would automatically close, but after a few months the door broke, which meant that I could not close the front door at all. I have described how I called the TMO using the emergency phone number to report this. The TMO sent round a handyman. He told me it was the self-closing mechanism in the door which had broken, causing the door to jam. He removed this mechanism from the door. This allowed the door to close again. He told me that he would not be replacing the mechanism, and to get the door to automatically close again, then they would need to buy a whole door. I assumed at the time that what he meant by this was it would cost money to replace the whole door, which the TMO would not want to do. I have included in the statement how the handyman told me that there were other front doors in Grenfell Tower which did not automatically close, and he said it was not necessary for my door to automatically close. In my repairs data, it says on 12 June 2012, newly fitted door has not been fitted properly. This might be about the front door problem I reported, although if it is, then it does not describe the problem properly. I'm surprised it does not include the change that was made to my door by the workman. And that's where I propose to stop with his statement. I will now go to the statement of Samuel Daniels, and the reference is IWS 402065. Mr. Daniels lived in flat 135 on floor 16 with his father, Joseph Daniels, who died in the fire. He also gave evidence in Phase 1, and you'll note that Mr. Daniels lived in flat 135 since 1983. Now, if we pick up his statement on page 3 at paragraph 13, Mr. Daniels said, "We had a new front door installed during the refurbishment, I think around 2011. This is confirmed by correspondence dated 10 February 2011 between the TMO and Mance Master Door Limited, who were contacted to install the new internal front doors," and he's given a reference MAS 6027. It was not self-closing and was much lighter than the original door. Sometimes the door would not lock by pulling up the handle. A key had to be used to lock the door. The latch would not engage and fully close unless you forced it to close. My housing file shows that the issue with the lock was logged on 28 February 2011 at 12:31 as overhaul upper lock and front door, and is recorded with the target date 3 March 2011. And he's provided it as an exhibit SD01. Despite this repair, the lock still did not function all the time. One evening, this fault was raised with the TMO by phone on an emergency line, as it was at night and the front door was not closing. According to my housing file, this happened on 4 April 2017. I remember a caretaker came out and took out the middle hinge in the door. This made the door close once you pulled it close, but there was still an issue with the lock system. The caretaker said they would come back and replace the entire door, but they never did. The housing file shows that the issue with the door was logged on 4 April 2017 at 17:04 as front door not closing, and is recorded as priority attend in 4 hours. Target date 4 April 2017, 21:04. The job status is recorded as approved, which is exhibit SD02. The following day, 5 April 2017, there's a log at 12:06 recorded as overhaul, complete UPVC front door with a priority of 20 working days and a target date of 8 May 2017, 12:06, and that's exhibited at SD03. The same day, there's another log. It is logged at 13:12 as please attend to front door lock as door will not shut. The priority is recorded as attend in 4 hours with a target date of 5 April 1712. The job status is recorded as a fully abandoned. Exhibit SDO4. There are logs for 5 April 2017 to renew front door and overhaul complete UPVC front door, and that's Exhibit SD05. And if we go to the next page at paragraph 16, he also says, months went by and nobody came out to fix it. I think about 2 months after the hinge was taken out, the self-locking system on the door stopped working. I do not think anybody came out to fix this. The log target date for 8 May 2017 never happened. Since the fire, I understand that a number of residents have had similar problems with their front doors. And that's where I propose to stop with Mr. Daniel's statement. I will now turn to the statement of Bilal Al-Ghanuni, and the reference is IWS 402034. This is his Phase 2 statement, and Mr. Al-Ghanuni lived in flat 152 with his wife Rabia Yahya and their children. You will recall that Rabia Yahya gave evidence in Phase 1, and I propose to pick up his statement from page 2, paragraph 7, where he said, I described the front door to our flat in page 3 of my MPS statement. Rabia described the front door to our flat in paragraph 10 of her first inquiry statement at page 109, line 2, page 112, line 24 of her oral evidence. The new front door was put in before, and then it continues over page, the major refurbishment in the building. I think it was a year or a year and a half before the major works. Like Rabia said, the new front door broke soon after it was put in. The hinges that were holding the door to the wall came loose, the door would jam. There was a way around that. You could lift the door slightly to use it. But one day the hinge with a long pole hidden in the door got jammed and kept the door open. Rabia called me and said she had to have the door open, so when I came home I removed the pole and screwed the hinges back on. The door was always loose, but now it was exceptionally light, even lighter than a normal door. It looked wooden, but it was feather light. It had some plastic element to it. Without the pole, we could shut the door, but it didn't shut automatically. We reported this to the TMO, but no one ever responded to our complaint or fixed the door closer. And that's where I propose to stop with his statement. I note that Rabia Yahya's Phase 2 statement speaks to similar issues, and the reference for her statement is IWS 402050. I'll now turn to the statement of Marcio Gomez, and the reference is IWS 401734. Mr. Gomez lived in flat 183, Grenfell Tower on floor 21 with his wife and his daughters, and they'd lived in the tower for 10 years. You'll recall that he gave evidence in Phase 1. Now, if we turn to page 12 rather, I propose to pick up, if we can scroll forward to the next page along. And forward again. If we can move up to the last page, sorry.
Do you want the previous page?
I believe so. I'm sorry, so I think I've misplaced the page number that I... Oh. Sorry, so I believe I've lost the reference, the page that I need for that statement. If I may have a moment.
Well, just take your time to find it, and there's no rush.
Oh, sorry, if we can return to page 4. Yes, this is right. Mr. Gomez has given evidence in respect of his front door, and he says, if I pick up at paragraph 10, and then he's quoted paragraph 59, I was not happy with the automatic closing mechanism on the front door as the door would slam shut. I was worried about the safety of my daughters, and their names have been redacted, and he says they were only 5 and 6 at the time the door was fitted. Our concerns were that our daughters might have had their hands by the door frame and the door would chop off their fingers when slamming shut automatically. I reported my concerns regarding the new front door to the TMO and asked them to remove the automatic closing mechanism. The TMO refused to remove the mechanism. I therefore spoke to a member of staff from the company who fitted the doors as they came to our flat a few weeks after the doors had been installed to inspect them and asked us if we were happy with the new door. I informed the gentleman that I was not happy with the door due to the force of the automatic closing mechanism. I asked him if he could take it out and he said no. He told me that I should wait for the final inspection, following which, if I wanted, I could remove the closing mechanism myself. I told him that I was aware that I could do it myself and asked him if there was a way to make the door less springy. He informed me that the door, and then he continues over a page, could not be modified, and I therefore had no option but to remove the automatic closing mechanism myself. I had not told the TMO that I had removed the automatic closing mechanism, but the TMO had been to my flat after the chain was removed and would have noticed that the door did not slam shut and never raised this with me. I would like to make it clear that removing the spring automatic closing mechanism did not stop the front door from closing shut. The door still closed shut automatically, but was more natural and not at speed. I and my family obviously always kept our front door shut when we were in our home or when we were away. On the night of the fire, the front door was completely shut. And that's where I propose to stop reading with his statement. I would note that his wife, Andrea Peristrello, has also provided a Phase 2 statement, the reference for which is IWS 401743. Mr. Chairman, members of the panel, this completes the BSR evidence that we propose to read into the record in Module 3. I would note that all the statements are signed and dated with a statement of truth, and would ask that all these statements are formally admitted into the record.
Yes, of course.
Finally, I would note that there are a number of other statements that the inquiry has received from residents of Grenfell Tower and also the walkways. I would like to acknowledge their statements by reading the names of those that we've received statements from.
Yes, thank you very much.
If the document can be called up, IDX 0706. Okay. So I will just read the names.
I think that will do anyway.
Okay.
I'm not sure
Okay.
we need to see them on the screen, so
I'm grateful.
thank you.
Abu Bakr Mohammed Ibrahim, Adriana Ramirez, Agnes Murray, Ahmed Al-Sadi, Ahmed Al-Assad, Ahmed Musaid, Alan Anwar Ali, Alemishet Demisi, Amina Kabu, Amina Mohammed, Anne Murphy, Antonio Roncolato, Aisha Gamhi, Aziza Raihani, Behelu Kabide, Benazir Lashari, Belanish Arai, Bernard Shaw, Bushra Al-Gurja, Brahim Al-Amin, Branislav Lukic, Cesar Ranito, Charlie Disson, Charlotte McMahon, Christine Bonnet, Christine Risha, Christopher Roncolato, Cordelia Disson, Daniel Brendan Griffin, Daniel Ude, David O'Connell, Diego Ortez, Dougal Stewart, Effie Sturgiopoulou, Elaine Lara, Elsa Afawoki, Esperanza Lopez, Esther Watts, Fadumo Ahmed, Fahad Vakar Malik, Farah Sarouk, Fatima Boujetif, Fatima Jones, Gennaro Batoan, Jeanette Gebremaim Shawo, Glenn Young, Giuseppe Raza, Hadija Archard, Halima Dejamoa, Hamza Jones, Hayat Al-Sanusi, Hazel Burke, Helen Gebrameskel, Hisham Sherbika, Jaime Haymanot Gashal, Hewitt Dagnachu, Ibtisam Al-Fawaz, Inez Alves, Isabel Renito, Ishmael Hadgay, Jackie Blanchflower, Jacqueline Haynes, Jason Miller, Jessica Gomez, Jevon Moses, Jose Vieiro, Joseph Carl John, Judy Phillips, Karima Al-Sawi, Karen Aboud, Kelly Dowlett, Khadija Yahya, Laila Raihani, Leanne Maya Jackson LeBlanc, Lena Hamid, Lubna Balfasi, Luke Towner, Mahmoud Al-Karad, Mahmoud Kabua, Manuel Miguel Ferreira Alves, Marcia Levy, Margaret Novel, Maria Gill, Mariama Al-Hassani, Mark Bennett, Marilyn Lopez, Melanie Urbano, Miriam Abdul Qadir Yusuf, formerly Nadia Yusuf, Meren McKennon, Mesrob Kasemjian, Michael John, Michael Paramasavian, Michelle Chiappetto, Miriam Lamfral, Mohammed Hariri, Mohammed Yahya, Monica Loco, Muna Al-Ogbani, Nadia Al-Buti, Naomi Lee, Nazanin Al-Ghalani, Ngozi Chijena, Nina Masro, Oluwaseun Talabi, Omar Al-Haj Ali, Otmani Benkaula, Paul Norbert, Peter Murphy, Philip King, Ramiro Urbano, Rashida Ali, Ravindra Manilal Ratnaika, Rauda Said, Reem Diedrich, Richard Fletcher, Rosemary Oyuwole, Sabah Abdullah, Saira Malik, Salah Eddin Chebuni, Salma Saeed, Sarah Mensa, Sepida Minai Mogadam, Sharon Lakey, Sharamin Benedict Bernard, Simon Jolly, Sophia Olivier, Tiago Alves, Thomasina Hessel, Virginia Sang, Viviana Rulo, Wesley Ignacio, William Wake, Winton Temesgen, Zainuddin, Zakaria Al-Sawi, Zora Al-Assad. I would ask that all those statements on behalf of the names that I have just read are formally admitted into the record.
Yes, thank you very much. And it's right that I should express our gratitude to all those who've taken the time and trouble to make statements for the inquiry. Although only some parts of some of the statements have been read out this morning, I should like to assure everybody who made a statement that the whole of their statements have been read carefully by the inquiry and will be taken into account by the panel when we come to make our decisions.
I'm grateful, sir.
Thank you very much.
I believe our next witness is due at 2:00. It might be a little bit early for the break, but
I am inclined to think that the sensible course, if it suits others, would be to break at this point and take an early lunch and resume at 2:15. How would that suit you?
very well, sir. Thank you.
All right, you happy with that? Ali, you happy with that? Yep. Right, thank you. Well, that's what we'll do. We'll break at this point and we'll resume at 2:15, please. Good. Thank you.